The Washington, D.C. rental laws provide fundamental rules for landlords and tenants. Becoming familiar with these laws can save both parties time and money. We're eForms, the world's largest online database of fillable legal forms, and in this video we'll cover the role of rental laws in tenancies, limits that the laws place on lease agreements, and how the rental laws shape Washington, D.C.'s eviction rules. Be sure to watch until the end of this video to find a link that will let you create a lease agreement that meets Washington, D.C. requirements. So what are the Washington, D.C. rental laws? The Washington, D.C. rental laws are a collection of statutes and regulations that provide greater detail about some of those statutes. The laws play an important part in determining the rights and responsibilities of landlords and tenants, but in most situations they should not be the first place the parties look. They should first consult the lease agreement, a written document signed by both the landlord and tenant that sets rules for a tenancy at a particular property. The rental laws do, however, impose limits on what lease agreements can do, even if both parties have signed them, and Washington, D.C. has more requirements than most states. For example, if a residential landlord requires a security deposit, the law states that it can be no more than 1 month's rent, and that no more than 45 days passes between the end of the tenancy and the return of the deposit, or a notification of any deductions the landlord is taking. The rental laws also require landlords to provide the tenant with certain information before the tenancy begins. This is known as a required disclosure, and Washington, D.C. has several that require specific forms. Check the link in this video's description to find links to all forms landlords are required to provide. For most residential properties, Washington, D.C. landlords are free to set rent at the beginning of a tenancy and establish a monthly due date in the lease agreement, but the laws do impose restrictions on some aspects of collecting rent. Late fees are prohibited until rent is at least 5 days late, and if a landlord does charge a late fee, it can be no more than 5% of the amount owed. The rental laws also determine how the eviction process in Washington, D.C. works. A landlord may terminate a tenancy for violating a lease agreement, but the process depends on the kind of violation. If the tenant has failed to pay rent or is not complying with some other lease requirement, then the landlord is required to give the tenant 30 days to address the issue or move out. If, however, the problem stems from some illegal activity, the landlord is required to give the tenant 30 days to move out, but is not required to give the tenant a chance to fix the problem. Washington, D.C. also has extensive rules regarding what landlords must do when terminating a lease in the absence of a violation by the tenant. Depending on why the lease is being ended, landlords may need to provide as much as 6 months' notice. Washington, D.C.'s rental laws can be complicated, but understanding them can help both landlords and tenants. For more videos on other property law topics, click the subscribe button below.